Are you there? Can you hear me? Can you hear me? I don't think I can talk. I got to figure this part out. We may not can talk until till we go live here. I'm not sure. Got to figure that out. Can you give me a thumbs up if you can hear me? Okay. All right. I don't think I can hear you right now. Let me see if I... Oh, it should be good. Hopefully Alphonse makes it on time, but if he doesn't, we'll just get started. And oh yeah, so we got YouTube. People are in YouTube talking in chat. Oh, the whole feed can hear me apparently. Not good. What's up, guys? It's good to see y'all all here. Thank you. Brandon, can you hear me? Trying to wait on Alphonse, guys. All right, ladies and gentlemen, greetings and salutations. Thank you, each and every one of you, for being here tonight to support the first official live stream of what I'm calling the Legal Beagle Network. My name is Gary, and I will be your host. My goal here is to organize the vast amount of information, knowledge, and experience that this Telegram community has compiled over the past 4+ years and put it into an easy to digest format that will both help the current community to be more effective in what they are doing and to reach new people to join the movement. We will begin interviewing those of you with pending litigation and creating content aimed at specific topics, thoroughly articulating how we got here and specific things you can do to begin to dip your toe into this arena. As you gain confidence and knowledge, I can promise you that you will feel empowered by this knowledge, and many of you will want to do more. We will do our best to help guide you in the process, from filing a simple FOIA request to litigating a complex federal case and dealing with lawyers. The current system of jurisprudence is corrupt in many ways, from delay tactics to flat out failing to follow the law, all in an effort to discourage you and create more billable hours for attorneys as they purposely delay the process. We have been trained to believe that it is best to leave this realm left to the experts, but it is our very absence that have allowed the infiltration of our judiciary and especially the American Bar Association, where they all protect one another and leave their clients and citizens holding the bill. This channel will attempt to give recourse via the law to those individuals that want to hold accountable those that aim to injure us, be it your neighbor, your employer, large corporations, or government in any form. It is clear by now that Brandon's massively shadow-banned YouTube channel cannot accomplish this goal, as YouTube has already taken down and now restored this channel on YouTube. And we didn't have any content till just now. To negate the behemoth tyrant of Google, we have expanded to 3 other platforms to help disseminate this information and give us added security and stability as we disperse this information to you. The other main goal of this channel is to raise our profile enough so that when the disinfectant light of the public's attention is required in a matter to help those in power make the right decision, we will be able to do so easily and effectively. I have done everything I know to have others help bring attention to these issues, including contacting state reps, attorney generals, congressmen, senators, the Judiciary Committee, watchdog groups, news media, and other popular podcasters. I even tried to pay for a national press release, but the companies that do this have blocked our attempts. So, this is our attempt to do it ourselves. Now, I don't relish the spotlight, nor being on camera, which is why I have not appeared on screen before. For those of you familiar with personality types, I am an INFJ. That should tell you all you need to know about me and my dislike of the spotlight. But it has become abundantly clear that something more outside of our comfort zone will be required from each of us if we are to save this once great republic. On September 18, 1787, one Mrs. Powell of Philadelphia asked Benjamin Franklin, who was leaving the Constitutional Convention, "Well, doctor, what have we got, a republic or a monarchy?" Mr. Franklin replied, "A republic if you can keep it." This is precisely what we intend to do here. Keep it. So I am obviously new to the streaming game, but I hope that I have done enough of my homework to bring you a quality stream free of technical difficulties. I guess we will see. I have aggregated the chats from all 4 platforms so that we might have an opportunity to converse with one another in a single place, and it should display on your screen. If not, we will address this issue moving forward. But rest assured, I will be able to see the aggregated chat and will be able to interject with your important questions and comments for the time being. With that being said, a few housekeeping matters before we get started. If you're watching via Telegram, you will need to find the topic marked live stream chat to participate in this aggregated chat in the Big Sim chat channel. Since we are starting a new YouTube channel and expanding to other platforms, the most important thing you can do to help expand our influence is to like, subscribe, and share this on all the available platforms. It's free and the least you could do. Every 10 to 15 minutes, the channel links to the other platforms will be automatically fed into the chat, as well as a PayPal address for any of you that want to contribute. Bringing this information to you in this format has not been free, but I have managed to keep the expenses to a minimum. So any of you that feel led to support us financially, I can assure you that it will be spent wisely and effectively. Tonight we will commence with a format that deviates a bit from my vision for this channel and allow a bit of a meandering conversation. We will get an update from Alphonse about what he's doing in Pennsylvania and what is going on with his cases, as well as an update on the now 6 cases that Brandon and I are currently litigating in federal court. Should anyone have a thoughtful idea on how we can improve the way we bring this content to you, it will be duly considered, and if possible with our limited resources, implemented. Without further ado, let me introduce 2 of the living legends that helped get all of this started. Alphonse Faggiola and Brandon Sidley. They join me now. I have to add Alphonse in here because he was a little bit late. Let's see. Let's show on stream. All right. Hey, Alphonse, what's going on? Alphonse, what's going on, buddy? Can we not hear me? Did we spend all that time saying that and it didn't matter? What? I don't. What? Can the chat hear me? Oh, God, that's not good. Let me see. I don't know what. I've tested this several times. But Brandon, you can hear me over there? Oh my goodness, what's going on? Let me see. Volume up. Settings. Here we go. Guess what? There we go. Now, how about that? All right. So much for the technical difficulties. So, I don't know what's going on. Brandon, you can't hear me? What in the heck is going on? There's not how. I don't have y'all muted. It's close. Testing. I don't know. This is set up correctly, as far as I know. How about now? Y'all are muted. I'm here. Can y'all hear me now? y'all can't talk or anything. I don't have y'all muted. Maybe Brandon and y'all could log back in. Y'all use the link again. Try to log back in. This went well the other day. I've tested it several times.
But
there we go. Can we hear Brandon now? Brandon, can you hear us? I hear somebody. All right, are we back on here? Oh, hang on. There's something up here.
Somebody got me?
I think I got you back in here. Let me see. Brandon, your guest. Wow. Alphonse.
Well, hello.
Oh my goodness! What a debacle! I'm sorry, guys. Again, Alphonse, can you hear us now?
I can hear you guys, yeah.
All right, I can hear you. So we're finally alive. I am so sorry to everyone. I apologize for the. I've tried this several times and it never worked that way before. So anyway, we're here now.
All that brilliance I spit out, I got to repeat again.
I'm just
on my head, if I can bring it out again,
I'm just glad my speech was. Everybody heard that. I hope. I don't know. Maybe not. Anyway, what have you got going on? I think Alphonse is the one we haven't heard from in so long. He's have his head buried in the sand, working so hard.
Yeah, you guys got.
Oh, Alphonse, you're cutting out a little bit on us.
I got the two, and then she said that's one.
Am I? We're okay on processing speed. I don't know if we have an internet problem here. I heard somebody join. I didn't see it. God. Dang it. I'm so sorry, guys. I am so sorry. At least there's only 62 and not 100 people having to suffer through this. Let me. Oh, I might know what the problem is. You back? Can you hear me? Brandon? Oh, where's you back is? Guess one. Okay. Now, Brandon? Alphonse. Okay, I'm hearing volume. Is that y'all back?
Yeah, can you hear me?
Yes, yeah. Yes. I had my VPN on. That was my fault. It's definitely my fault. I need to make a checklist. I went through all the chats to make sure they were working, and then the VPN was on, so it delayed everything. I think we should be fine now.
Right, so the first case he tried to get rid of by calling it a tax injunction case, a tax case. So I filed a motion to reconsider of the local rule, and he's sitting on that right now. I've heard no response. The county filed their response to the motion to reconsider. He's sitting on that because what happened is I filed.
Alphonse, real quick, can you re-say what case you're on? I think a lot of us probably missed that because you were frozen for a little bit and whatever.
The first case I filed was the county property tax case. Okay, that's the main case.
And you filed it in federal court, right?
Federal district court, yeah.
All right.
And the judge, when I had the hearing, I toured her. If you hear recording, I ripped their lawyer up in the hearing. He got his ass kicked. Okay. Now get this. Here's the bias of these people. He's over there arguing Rule 8. That's the first thing they throw you. Rule 8. Oh, your pleading's too long. You only got to be short statements. That is not what Rule 8 says. Okay. Here's what Rule 8 says. You must make at least a short statement of what you're bringing a case for. At least. Doesn't say only. It says at least, so that the other side knows what your complaint's about. So the attorney for the county got that wrong. He got Rule 8 wrong. And then he was over there pleading. Now get this. They're a county. Okay? They're a person under law, which means they can be sued. He's arguing 11th Amendment immunity to the judge. Oh, no. You're a county. You don't have 11th Amendment immunity. Now, this is a licensed lawyer, okay? Representing an entire county. Big law, Philadelphia law firm, okay? He's got the 11th Amendment wrong. He's got Rule 8 wrong.
Yeah.
Now, get this. I have a discussion with the judge over Rule 12 because we all know about Rule 12. The first thing they throw at you is a rule. They're going to throw a 12B1 and a 12B6 motion at you, okay? Then everything halts when they file their 12B motions. Everyone sits on their hands and everyone goes on vacation. We don't hear nothing for 3 months, 6 months, until the judge 10 months, okay, till the judge turns around and says, oh, I got a case here. No. Listen, me and Steve, we disagree with how to run in this 12B rule here. Listen, when that 12B rule gets filed, that's up to that attorney to set a hearing, to set a motions hearing for his motion. He just files the 12B motion, and everything goes off into the ether, and it sits there forever. I'm sorry, that's not how that's written. Nowhere does it say when you file a 12B motion that the response that they're suspended. Okay, they got to give you a response. It doesn't say when a Rule 12B motion's filed, it suspends everything until the judge gets back to you. That's not written anywhere. So me and the judge had a discussion about this, and I still am not convinced I'm wrong on this.
So they actually set a hearing for you?
Yeah, I pressed for a hearing. Okay, I banged his assistant for a hearing. At first, she had no trouble talking to me until she found out I was pro se. Oh, then all of a sudden she's telling me to read the rules. Oh, I did read the rules. Says I'm entitled to a motions hearing when I asked for it. I want a motions hearing. Demanded a motions hearing. Well, I'll talk to the judge. I want my motions hearing. You know, dude, 2 days I banged her. Next thing I know, boom, she's scheduled a motions hearing, okay? Squeaky wheel gets the grease. So we get in there. So me and the judge had a discussion over this 12B motion. Like, he gave me his view, and I asked him, show me what law or what rules say that when a 12B motion gets filed, it suspends everything.
Brandon.
So we have this discussion about the 12B motion, and so the judge, now get this, here's the bias. Mr. Fagiolo, I understand that, you didn't go to law school. Well, what's that got to do with anything? What does my interpretation of a rule have to do with me going to law school, okay? I didn't go to law school, but I made a good argument for the 12B motion. And you couldn't show me anything that said when they file a 12B motion, everybody's got to wait and I don't have to get my answer. He couldn't show me anything. But then he turns around, he don't criticize the other attorney who's got the 11th Amendment wrong, got the entire 11th Amendment wrong, and he's got Rule 8 wrong. Didn't criticize him at all. But me, he had to get a little jab in his. The reason, the 12B motion, the discussion we had, maybe I didn't understand it because I didn't go to law school. Who cares if I went to law school? So right off the bat, you have a bias, all right? You know you're dealing with a judge that, I'm sorry, if you got a bar card, they're treating these people differently than they're treating us. And it doesn't matter whether we can run circles around them with the law and the rules. They give them every deference of opinion. They give them every advantage possible. They'll let them skate on. And here's the famous one. Brandon's starting to see it. I'm sure you're starting to see it. You know in these local municipal courts, you're going to lose no matter what. I don't care if God himself came down to be your witness and testify for you, you're going to lose in the municipal court. Then when they railroad you in the municipal court, and can you hear me? When they railroad you in the municipal court and they sue you in federal district court, what are they going to say right off the bat? Rooker-Feldman. Oh, you're a loser in state court. You can't bring this to federal court. So now I'm thinking, you get in a dispute with the local municipality or somebody, and they're trying to drag you in a municipal court or a state court. I'm sorry, I think you got to go to federal court right away. I think you file right away so that you don't become a loser in state court, because that's what they want to do. They're setting it up so that you can't get in federal court.
So can you give us a little bit of your conversations with the judge's assistant that convinced him to have a hearing? Because I've tried a couple of things you suggested, and and it didn't go as planned.
Well, when they filed their 12B motions, and like I said, me and Steve have a difference of opinion on we don't believe that suspends their answer time. Okay.
Well, it shouldn't.
They got a lot of time. They got a lot of time to file that answer. So if they want to file 12B1, 12B6 motions, that's fine. But then when you file that motion, what does Dr. Graves tell you right away? It's the responsibility of the party filing the motion to set the motion for a hearing. It's not my job to set his motion for a hearing. So we're sitting here in la-la land because once the 12B motions get filed, everything stops. So Steve said, fuck that. Let's go file over top of them. We'll file a motion for summary judgment, right over top of them. We filed a motion for a summary judgment. Hey, never got my answer. So now there was a dispute. Got the 12B motion sitting there, and I got a motion for summary judgment on top of them. And they're kicking and screaming about the summary judgment motion. So in a way, it sort of forced their hand into having to resolve this. Hey, I want a hearing. I got a motion for summary judgment. I want my motion for summary judgment.
Hey,
yeah.
We've got problems. It lost the YouTube stream.
Okay. I don't know what's. We lost it altogether.
Yeah, I'm just watching a couple of the streams while we're going. I hate for us to run through all this for 2 hours and nobody's going to watch it. I really would hate to do that.
Well, they're still posting right now, so over here.
Yeah, okay, there we go. It's coming back. It came back. All right.
Okay. All right.
Nope, gone.
So yeah,
refresh it.
It created a little bit of a dilemma for them because I had a motion for summary judgment on top of their 12B motions. So I kicked and screamed, "Hey, listen! I want a hearing because in the local rules it states that if one of the parties requests a hearing, that they can set a hearing for you." So I kicked and screamed, and I got my hearing. And I literally, I'm sorry, I kicked his ass in the hearing. Their attorney got his ass kicked. Okay.
I don't doubt that.
He didn't know the law. He didn't know the 11th Amendment. He don't know the rules. He didn't know the rules to save his life. Okay. And the judge who said, "Well, Mr. Fadjol, you know this tax stuff much better than I do. It seems like you put a lot of time into this." Yeah, I put about 4 years into this, Judge. 4 years more than you did, okay? So he said, well, it's going to take me about a month and a half to make a decision when he asked for memorandums in 30 days from us, okay? It's going to take me another month and a half, he said, to make a decision. The memorandums go in. 2 days later, he grants their motion to dismiss. Not on the merits. He didn't say the merits were flawed. Oh, it's a tax injunction matter. And here's what a tax injunction matter is. It's them claiming that you have a fast, speedy, and efficient remedy in state law. Well, no. A non-taxpayer doesn't have any fast, speedy, or efficient remedies in state law, okay? It's like trying to say, well, Mr. Fagioli, you're pregnant. You don't need to come here to fight us. Listen, there's a fast, speedy, and efficient remedy for you in the state court. Well, no, I can't be pregnant. I don't have a uterus, okay? I can't carry. Well, no. But this is the ridiculousness of what they're trying to say. They're trying to claim that, listen, I can't become a taxpayer because I bought a house. That's not how it works. And I can't become a taxpayer when I get a job. So they want to call you a taxpayer. And then they want to say, well, no, this is a tax matter. You have a fast, speedy, and efficient remedy in state court. Now listen to this. Here's your state remedy here in the county. If you want to challenge your property assessment, you can't challenge the assessment itself. You can only challenge the value of the assessment. So you must then do two things to get a hearing with them. You must bring in a comp sale of the property. In other words, what the property sold for. Or you can hire a third-party assessor to give you an assessment of the property. Then you take those two values, you bring them to the assessment board, not so whether they can make a choice whether the assessments are good or bad, like to get rid of the assessment. It's so that they can choose a value. Well, that's not a remedy, okay? I'm saying you don't have any authority to assess the property. I'm not arguing over the value of the assessment. I'm arguing over it. You don't have any authority to do an assessment. So there is no remedy. So he tried
it's a complete circle, right? They're using circular logic by the assumption that you are a taxpayer because we have traded rights for privileges, and we've been at it for so long. You're in the third or fourth generation that neither the most judges nor do the attorneys know what an individual right is. And that the government's job is to secure those individual rights so they flip-flop the idea of a constitutional republic in the first place, which is a limitation, a document of negative liberties against all government, all forms of government in the United States, and its primary job is the servant to the citizens. Well, we've gone back to many of the different collectivist ideas in the past where the government is now the master, and you can call it fascism, call it communism, but it's just a collectivist state. The truth of the matter is, folks, if you do not have a right to property, you do not have a right to life. And what do I mean by that? I just want to interpose some of these ideas, foundational truth. The right to life means to be from physical compulsion or coercion. Okay, a tax collector coming to your house and saying you owe me money without due process is coercion. Okay, that's all it is. It's nothing else. It's actually this is against the moral principle of individual rights. That's it, because this is a moral precept. It's free from physical compulsion or extortion. That is what individual rights in the constitutional republic mean. And what Alphonse is saying here, you just talk in circles to these people, because the foundational truth that we're talking about in that we have a right, it cannot be sold or taxed or anything else. They'll never bring up that fundamental truth. They'll talk all around it. They'll send y'all out everywhere. But make no mistake, folks, this is something worth keeping, what was built here in the United States. Go ahead, Alphonse.
No, and here's the circular logic, and it's cognitive dissonance, because now get this. Pennsylvania defines taxpayer very clearly, okay? There's corporate taxpayers, and then there's individual taxpayers. Both corporate and individual taxpayers must file income tax returns, okay? Must file returns. That's what a taxpayer is in Pennsylvania code. So I got this all in my suit laid out. The attorneys come back and say, no, Mr. Fagioli's got this all wrong. He's conflating corporate taxes, property taxes. No, they're one and the same, okay? Now get this. And when they make this argument that I got it wrong and I'm conflating corporate taxes with property taxes, all the cases they cite, guess what the cases are? They're taxpayers. They're corporation versus corporation. ABC Corporation versus DDF Corporation, okay? Every case that the attorney cited, if they're arguing, and I got it wrong, that that I'm conflating corporate taxes with property taxes. I got this all wrong. Every case they cited was corporation versus corporation. In other words, registered taxpayer with the state versus registered taxpayer. Not one case was it Joe homeowner versus the municipality, or there was no Joe homeowner cases because Joe homeowner is not a taxpayer under the code.
They seal those cases.
Well, and what we did in our motion to reconsider, Steve said print those cases out. There were 3 cases the judge cited. All taxpayer versus tax. So he said, go through there and highlight everywhere it says taxpayer. Here's you go look at what I filed, my motion to reconsider. I printed all the cases out, and I went through with a yellow highlight marker and highlighted taxpayer about 100 times. Taxpayer, 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 taxpayer. They're talking about taxpayers. And then I had real good case law I put in my motion for reconsideration where it talks about the revenue laws are written for taxpayers, not for non-taxpayers. And it states that the Congress, they don't intend to deal with non-taxpayers. And some of these cases came right out of Pennsylvania. So I think that now has the judge a little bit perplexed. But like Brandon said, listen, they've never heard the term non-taxpayer. If you're breathing, you're walking in the state, they think you're a taxpayer. Oh, you're a taxpayer. You own property? Oh, you're a taxpayer. They never heard the term non-taxpayer. And if you heard my hearing with that judge, and I said, Judge, he said, well, Mr. Fagioli, he said, I get the county sends me property tax bills and this. And I said, Judge, you're being ripped off. Your county's ripping you off. And he sat there and he looked at me, but it's the truth. Now, he don't care. He's making $250,000 a year. I think that's what they pay them judges here. And he's a senior judge. He might be making more. He might be making $300-something thousand a year. So he don't care about the $7,000, $8,000, $9,000 tax bill. That's nothing to him. But to Joe homeowner like me, Brandon, you, 10 grand's a lot of money for us, okay? It goes a long way to feeding our families and helping our friends and all than it does to support these local municipalities that are running unchecked, okay? And here's why I press for this stuff. You got New Jersey's right next to Pennsylvania. There's a township over there called Brick Township. Brick Township, their taxes were up to about $22,000 a year. Did you hear that? $22,000 a year for the average home, Brick Township. Now, let me get this straight. If you live in Brick Township, Gary or Brandon, and you can't pay the tax, the $22,000, right? Your only option would be to sell your house, right? Or you're going to lose it. Well, when you go to sell your house, how many people do you think want to buy your home with your $22,000 a year property taxes? How about probably none? So let me get this straight. You can't afford to pay your property tax, but you can't sell the property because the property tax is so high, nobody wants to buy your property. So what's the option? You just lose the property? You just lose your property then?
Well, probably, but we know that the Sixth Circuit is taking up the takings clause about that, so that the municipality would have to put a lien on your house rather than take your home or sell it. Or if they took it and sold it, they would have to refund you the amount of money that you didn't know. They don't just get to keep it all now.
Well, and here we go again, right? Because this is important here because yes, we're up against judicial activists and critical legal theorists and everything else, but the black letter of the law, which is the Constitution, which restricts government's access to the private citizens' property, over the years have completely gone away from the Constitution. For example, Keto versus New London, I think it's 2005, where the public use doctrine was turned into public function doctrine, and the courts themselves have become an extension of the executive branch, the administrative state, therefore circumnavigating the separations of powers. Now, look, folks, I'm not telling you it's rosy out there, but I'm telling you, if we want to keep our freedoms and our liberties, we need everybody in on it. We need as many people talking about what we can prove, objective facts, materially based, not somebody saying all banks are commercial or The UCC code is where we're at, or you need a all that stuff is irrelevant. If we go back to objective based facts based on empirical evidence and intelligently articulate our individual rights as secured by the Constitution of the United States and get these judicial activists out of our courtrooms. It's everywhere. I don't care where you turn in society. They've infiltrated all 5 pillars. That's the media, that's religion. I don't care where you go. They've infiltrated and subverted all of them to one of the many branches of collectivist ideas. So in Kelo versus New London, it's an important case. It's one of the judicial activist cases where they moved the public use to public function and created ex post facto laws that actually circumnavigate the takings clause. This is a huge deal because now we're allowing the municipality, which is a creature of statute. It's not the state legislature. It doesn't have the power and the authority of the state legislature. Yet they're creating the taxes against everyone else. And this is antithetical to the United States Constitution and a free society. Again, it's by physical compulsion or coercion.
Yeah, and let's specify with the takings clause. Takings clause is actually like a seizure, okay? They may not have physical control of the property, but if they're doing something, exercising control and interfering with your right to use the property in some way, that's called a taking, okay? It's a taking of the property. They're interfering with your rights to use your property, which our municipalities are famous for, okay? Like when I put 4 years ago, when I put a roof on my house in Ridley Park, the code idiot stopped and literally stopped the job for 30 days. So I didn't have use of the house for 30 days because I had to get the goddamn roof fixed. I needed the roof fixed. That was a taking, okay? In other words, he was interfering with my property rights. So though they didn't have physical control of the property, they still seized control of my property rights. So when he says takings, think about they're taking your property rights. They're seizing your property rights. It doesn't mean they have the property physically under control, but they're seizing property rights that they don't have. And there's a great case I used in my the last motion I did for the judge in my Borough Ridley Park case. It goes into the takings clause in detail of what the takings clause is, and it flat out says that executive branches and administrative branches have no authority to be taking property from people. Nowhere were they granted rights to take property from people. And the only way they can take property is through eminent domain. And in eminent domain, they must justly compensate the party. Not even in takings, was what Gary was talking about, where they take the property for taxes. Here's what they were doing. If you had a $300,000 house and you owe $10,000 for taxes, they just stole the entire house from you, sold it, took their 10 grand, and you never got a penny back. So they would have to give you.
The entire framework of the property tax is based on the implementation of the Social Security and everything else, which is gone, by the way. But if in our system of jurisprudence, the right to life is the source of all our rights. Okay, the only implementation is the right to property, and that means your piece of land cut out, your piece of property, your whatever. If you have no property rights, and I want people to really digest this. If you have no property rights, no other rights are possible. And think about that, because if you don't have the ability to sustain your own life without somebody else coming in, grabbing your property, the value thereof, or the effort from your labor, right? Or the effort from your labor in money or other things, and pulls it out to give it to other people. Well, folks, that's socialism, and that is contradictory. That is in contradiction to a constitutional republic. From the very basic of all of this, if we take it all the way back down to the fundamental truth, right? The basic necessity, just think about it simply, logically deduce. If I come in and I take from one to give to the many, what have I done? I've stolen from the one, the individual. I have forced the individual to subvert himself to the collective. Okay. This is actually in contradiction to the United States Constitution and our Declaration of Independence.
Yeah, and that's why
It's that simple. It's not complicated. So it really isn't. The man, and look, the 13th Amendment, right? We can't have any chattel or any slavery. The man who produces, in the simplicity of the statement, the man who produces while others dispose of his product is nothing more than a slave. It's just that simple. We don't have, and I think I'm going to get a little bit simpler in my appeals because I'm going to start speaking to the logical deduction and for instance, just quickly while I'm on the tangent, the motion to dismiss in my daughter's case was granted. So now I have to go to the appeals court. He skips over the fundamental truth, which is that's missing from his entire opinion, which is how did Dr. John Heaton and Dr. John Heaton and Greg Fern gain a legally cognizable interest into my daughter's life, liberty, and property, her consciousness, her freedom for bodily autonomy, and any other right that she has to her temple. Who granted that right to these two individuals? Well, until that baseline fundamental truth is discussed, everything else after that is a false logical deduction. And if we can continue to dial in on these falsities that these judges and these judicial activists do, they'll take one point, but they'll skip A, B, and C and come down here to D and start working down. You have to catch it. You have to catch the logical fallacies that they continue to do in each and every one of them. But if we stay to the core, and we're going to have to stay to the core, because you're not going to win by doing the procedural circle jerk, because they're just going to give it to the attorneys. That's exactly what they're going to do. They're just going to go ahead and give it to the attorneys. And I'm going to tell you right now to everybody in this group, there's thousands of us. Okay. There's literally no way that thousands and thousands, if we get up to 100,000 and we've got, say, 10,000 people that are doing a writ to the Supreme Court, now we've got the percentages in our favor to get one of these cases in front of the Supreme Court. That's what has to be done. There is going to be a lot of weeping and gnashing of teeth, but we have to live in reality now. Where we are in reality now is the letter of the law is being ignored in most courtrooms. The only way, folks, that the letter of the law is not going to be ignored is if you so happen to pull a trial court judge who's an originalist and a textualist, which means that the Constitution and the black letter of the law actually means something to him. All the other ones are statists through and through. So do not get discouraged. You're fighting something much bigger than what most people understand. Yes, they ignore the letter of the law. We left our duty. The people, we got fat, we got happy, we left our duty, and we let these criminals infiltrate the government. And now we have a mafia running the government. That's what it is.
So Brandon, are you saying that the rules do not rule?
No,
because they'll keep in mind.
Not for me, okay? That's the legal society. Rules for thee, not for me.
That's right. What they're doing, even if you catch the lawyer in a lie, so judges openly ignore the black letter of the law, the plain, ordinary meaning of the text. They circumnavigate the actual rule of law, right? And they say it's the law.
They're using doctrines to supersede the Constitution.
They're creating and they've been doing it for a long time. People don't realize this. So it's against the law to create an ex post facto law. Okay, that's in our Constitution. What does a judge, for instance, and I'll give everybody clues here. The Supreme Court's doing a good job. They got rid of affirmative action. They got rid of Roe v. Wade. What both of those cases were the judicial branch becoming the legislative branch, just like in Kelo versus New London, United Steelworkers versus Weber. There's 150 different cases out there that have transpired since about 1907 that the judiciary has created laws that we are following today that are not laws. They are in contradiction to the United States Constitution, and we have allowed these judges to create stare decisis on these false rulings. And look, you have nobody to blame but us. For instance, there's nothing. The United States Constitution is so simple. It is so simple, an eighth grader can understand it. All you have to do is read the Federalist Papers and the Anti-Federalist Papers and get both sides of the idea. Read John Locke's Second Treatise of Government, and you'll understand where the idea of individualism comes from and the beauty that was the simple concept. The problem has and will always be that when good times come, mankind's nature is to get complacent. And while all these crooks were working in the background, steadily whittling away at our rights, we were just lost at the steering wheel because guess what? We had plenty of money.
Brandon, which branch created judicial immunity?
The judiciary.
How did it work? How did that happen, right?
Well, the Hicks Doctrine.
Is your judicial immunity.
That's right. The Hicks Doctrine. We've got all kind of doctrines that they create, that the judicial branch has created these doctrines that protect. Here's the fundamental truth. We secure these rights for the individual, right? And so we institute government among men. However, it's been flipped on its head, and they're creating doctrines to protect the government from the individual.
Yeah, that's what the that's what the Rooker-Feldman is, and that's exactly what that is. How do you take a doctrine and supersede somebody's property rights?
Well,
how does that work?
So the Heck Doctrine, the statute of limitations, all are being misused.
Absolutely.
Well, yeah, because the common law doctrine, and if anybody wants to listen, folks, in the common law, you had a 3-year civil statute of limitations. Okay, so the layman in the common law, you and I, if I had 3 years from the date of my injury, 3 years is a long time, even for somebody working. You could probably put a case together. Now, most of these states have moved to 1-year statute of limitations. This takes years to compile all this information. Hell, we've been on Telegram 4 years now? 3 years, 3 years with active cases going. Some of them are 16 months long, 18 months long. The truth is until you get into the fight, you really don't realize how nasty it is. I'm not here to pump sunshine and roses up everybody's butt, but we do have a duty as a civil society to keep the freedoms for our progeny. Guess what, folks? We're in a dogfight, because if we just give up, it's going to be communism for all of us.
And if you don't think they're watching this, listen, get this. When I filed the property tax suit, Steve's done dozens of suits in Florida, okay, and other places throughout the country. He had never seen the Tax Injunction Act used as a defense. First time he seen it come up, okay, was my case. I got a guy in my group, okay, I think Benny Blanchard, his name is, he posts. He literally took my case and crafted his case. He lives in Florida, where Steve lives, okay? He filed that case in Florida. 12B1 them, 12B6 them. Right away, they hit him with 12B1, 12B6. And what did they hit him with? Tax Injunction Act. Now, Steve said he hadn't seen that down in Florida. The court came back, the attorney down there in Florida used the Tax Injunction Act, which Steve said he hadn't seen in dozens of cases he's been involved in down there. So all of a sudden, the Tax Injunction Act has risen its head from the grave and is popping up everywhere. This is the way they're trying to quell this property tax stuff that's raising its head. Okay, I don't think that's an accident. That the Telegram groups and the cases and all of a sudden Steve's never seen it down Florida, and now some guy from Florida files a suit, and bang, there's the Tax Injunction Act that's made its way to Florida too. It's reared its head. I think there's a lot of people watching what's going on. Okay, they're watching the cases that are getting filed. And if you ever heard that great recording from Genghis and for his case, where the attorney, he's talking to the judge about the quality of the pleadings, okay? Ron from my group and Rachel. And he said, these are sophisticated pleadings. I think they're getting help from somebody, okay? They don't think the dummy pro se's could write this stuff up. They think they're getting help from somewhere because the guy said these are pretty sophisticated pleadings. He said it in a way that was actually very complimentary. In other words, these aren't dummies writing these pleadings up. So this stuff's starting to take a life of its own. But like Brandon said, there's 10,000 of us in my group, and out of there, how many have suits, Brandon? Maybe 10?
Yeah,
10
yeah, and what people, I don't think people really understand. So, unfortunately, most people, and I'll go off on a little tangent here because this is going to touch into many people's philosophical or religious beliefs. Many people have been programmed to believe that second coming's coming, or some messianic reign is coming. No, folks, you're supposed to overcome this world. Okay, you're not. If you're sitting around waiting on some bad event to happen, guess what is going to happen? How about let's do some good and apply ourselves and our knowledge base. Let it grow. Yes, if it was easy, everybody would do it. But I'm going to tell you right now, there's a great. For instance, Genghis Khan got his, and then in our civil suit against Carl Bryant and the Mississippi Band of Choctaw Indians, we were accused of having a ghost. He actually named the attorney of ghostwriting our complaint. It's not your complaint that this is the problem, folks, and don't deviate too far from the basic fundamentals. That's why if anybody's missed the Cultural Marxism series, and especially number 4, where I go deep into judicial activism versus judicially restrained. If you stay to the basics, and enough of us do this, we get into the appeals court and we start getting rulings, and we're able to share this publicly, the rulings, and we get enough. Look, this is the thing Gary brought up at the beginning, and I need to hit on while I'm on this tangent. One of the things that we fail to do as a member society is that we do not share and publicize each other's stuff. Publicity does help with these things. Okay. We're not going to get it from mainstream media. We're not going to get it from Tommy Tutu's blog or anything else. But if we don't support each other, we're just pissing in the wind. We've got to do a better job of that, myself included. But we have to get the whole reason for the start of this YouTube channel is you put my name on any YouTube channel, and guess what happens? It's blocked. Hell, I don't understand it. I'm such a big bad guy. I just want to stop COVID-19 tyranny and tyranny of the government.
there goes the shadow banning.
Yeah.
No, so
yeah,
you got to file. You got to learn, and you got to start filing. And until people start filing, like Steve said, the only way we're going to fix this is county by county, okay? You're not going to fix it from the top down. It's going to be from the bottom up. It's going to be from, instead of having one of me in this county filing, if there were 4 or 5 other of me filing in here, they'd be going through hell right now, the county. They'd be in trouble. But they got one guy. And Steve said the problem you're having is you don't have the media behind you. In Florida, he's got like a whole media setup where they got people calling and, and they got newspaper reporters writing articles, and that famous case Steve did, they had the FBI agent calling the county numerous times to find out how they threw this guy out of his house over like $8,000, ruined his life for $8,000. $1 million of his stuff they destroyed, killed all his animals in a week, and sold his house for $8,000. And so he's got the media part working for him. And Steve bangs on that's so important to get that out there. But that's the hardest part, is getting that media, getting somebody to make calls for you, or getting people to call for you, because you're going to need that pressure coming in. Like if I had 50 people all the time calling the county asking why are they not answering this suit? Why is their answer delayed, or why haven't they given an answer? Because think about it this way, Gar. If my property tax suit was way off base, right, and I filed the property tax suit, why did an attorney just turn around and file like a 20-page document and say, Mr. Fajola has this all wrong. Here's how we're taxing his property. Bang, bang, bang. Here's the laws. What does he argue? Oh, Tax Injunction Act. Oh, Rooker-Feldman. In other words, he's not talking about what's in the complaint.
No,
He talk about
yeah,
things, this doctrine, that doctrine, this rule. He ain't talking about what's in the complaint. My
that's right.
problem right now is
That's
I
right.
need that judge. I need the federal judge to do one thing: get the hell out of the way. Okay, get out of the way and let me get my answer. Because right now, I'm going to go after that judge if I need to go after judicial complaints, whatever. I'll go after him. Because right now, he's a barrier to me getting an answer. When I file a federal lawsuit and it's got validity to it, what are two things you need to file a federal lawsuit? You must plead that a right was denied, right? And that you suffered damages from it. And if you plead those two things, which are pled numerous times, you're entitled to an answer. Not to get your case knocked out for the Rooker-Feldman Doctrine or the Tax Injunction Act. You need the judge to get the hell out of the way and let them give me an answer. Because when he does that, then we come to settlement because we're not going to trial. They're going to lose in trial. So that's the problem you are having, Gary, and Brandon's having. We got the judge running interference for the other parties right now.
That's
we can't
right.
even get an answer. We can't even get an answer to a lawsuit. Like,
well, and it's a shame though, because I don't think. Look, I'm suing a judge right now, Shelley D. Dick. And that case is still ongoing. I file a new case against Wildlife and Fisheries, and she gets assigned to the case. She won't. I've done a recusal, motion to recuse. She won't even recuse herself from that case. Now, can she possibly rule on this case? No, but she's going to sign the order that motions to remand it back to state court. And as soon as she does, I'll appeal that because she has no reason signing any order with this case. But nonetheless, out of the 6 cases that we filed, now listen, folks, 6, too many. Yeah. We've done too many. Matter of fact, it's run me spiritually dry at times, where I just lose the passion for this. However, out of those 6 cases, it can't either the percentage of left-wing progressive judicial activists is much higher than what we thought, or they are assigning us to these leftist ideologues on purpose. And I personally believe that's my hypothesis. I have no objective facts to back that up. It's just strictly based on the amount of.
Well, we have a few. Mm-hmm. Objective facts to prove that.
Well, yeah.
There are like 30 judges in this federal court in Pennsylvania, okay? There's like 5 or 6 senior judges, all right? My tax case, I get one of the senior judges, okay? They always. Okay? Now, he's got that case, and then I filed a second case. Guess what judge I got?
Same one.
Judge.
Yeah.
What are the odds of me getting the same judge? Because Steve said, listen, that's supposed to be like a random thing, what judge gets assigned, I just happen to get the same judge.
Yeah.
Next case.
Yeah. In 5 of our 6 cases, we've been assigned the chief judge in that district, and we are in 3 or 4 different districts. We're in 4 different districts. We have been assigned the chief judge in each one of those. Now that's not possible. Yeah, right. Yeah.
So and look, so the doc these and here we go, guys. So what do so how do I say this? So the rights of the individual in a constitutional republic puts the government in a servant class. Okay. That's the goal of a constitutional republic. And the only goal of the government is to protect the citizen from criminals and government. What happens when criminals and government combine? Okay. And I'm not a sunshine pumper. I'm a realist, and the objective facts are here. The empirical evidence is here. The criminals and the government has combined arms against us, we the people. And so it is our duty, like I said, to put an end. And we've got the best Supreme Court that we've had in 100 years, by the way. Getting to that Supreme Court is the issue. So the only way that we have an opportunity is go through the appeals court and continue on up the ladder now that means it's 3 to 4 years out, folks, because I don't know how fast they're moving in everybody else's cases, but it's been, matter of fact, it took 11 months to rule on a motion to dismiss for Brandy's case.
That's
Brandy's
ridiculous.
case. 11 months. 11 months.
That's what I was saying, where that's that 12. Listen, and when I do the appeal, and I'll get help from Steve, we are going to address this this Rule 12 thing. We want a response from the appellate court telling us that how we got this 12B rule motion wrong, where they can file that 12B motion and you got to wait 11 months to get a response back. No. I'm sure that's not how it's written, because in that Rule 12 motion, it doesn't say that, well, when the 12B motion's filed, everything halts. No answers have to be filed. Nothing has to be done. And you just sit there and wait till kingdom come, 11 months to get an answer. That's not a fast, speedy, and efficient trial Brandon's getting, okay? He waited 11 months to get a motion, and now he's got to do an appeal. That's going to run another year probably, okay, the appeal.
Well, in this particular case, the judge has made this ruling after the last 3 months. The government's admitted that they made up the 6-foot rule. Vaccines aren't safe and effective. And we all know now that the DOD owned all the vaccines. Okay? The Department of Defense owned all the vaccines because they purchased them all and then distributed them all themselves. Okay? So the government owned the vaccines, and then the private public partnership that existed forced the vaccines. That's contrary to the Constitution. And again, this is all stuff that this judge just seemed to forget in his opinion, right? Is the fact that the public-private partnership, and here we go. Here's the simplicity of this, guys. Public health is a doctrine that only who can enforce? The government. That's it. It's an abstract idea, and here, anytime you hear anything about society or social or public or anything else, this is an abstract idea. It has no objective reality. The only thing that is objective is the individual members of that society. It's an abstraction, okay? So when they come in and try to tell you that it's for public health, that's without any objective facts to base their rulings on. So from that point on, it's a false premise that they're basing everything on. So that's how I'm going to attack the appeal, because the judge just jumps over from A to C, okay? And it's a logical fallacy. It's crazy how they do this, but here's an issue that we all face, okay? And it's sad. But the truth is, intelligence, how do I put this? I'll tell you what, I'll read from my little document right here from Barbara Oakley. Let me pull it up real quick. If you think because somebody has a high education and that they know how to use their critical thinking faculties correctly, you are sadly mistaken. Intelligent people are the worst offenders for going with their confirmation bias. Intelligence is no safeguard regarding these confirmation bias related issues. Highly intelligent people, for example, do not reason more even-handedly and thoroughly. They simply are able to present more arguments supporting their own beliefs. That's what these judges are doing. And especially with COVID, anybody got any COVID-related lawsuits? If your judge was a branch COVIDian, do you think that they can possibly rule without bias? They can't. They cannot do it. Same thing with Alphonse's property tax. If they're a status, okay, and if they've been brought up to believe, what's that saying? The only two things promised to us is what? Taxes and death. Well, dude, this is indoctrination from yay high, and that's a fundamental core belief of 90% of society, because no one, hardly any, I can't say any absolute statement, almost no one understands the basic fundamental truths of the Constitution and what individual rights mean. And without that, you're kind of beating your head against the wall. We have to bring it back. And unfortunately, in some generation has to do it. I guess we're called forth to do this. That's why Gary's pretty little face is on the screen now.
Unfortunately.
And to step back to what Brandon said, and whether it's property taxes, no matter what it is, they jump to point B. They skip over point A because the municipality argue, well, we have this right in the tax code to do this or do that. But then when you go back and look at the Congress that passed the law, the statutes, well, if the Congress can't do it, the Congress can't put a lien on my property, okay? The Pennsylvania Congress can't lien my property, okay? The Pennsylvania Congress cannot seize my property. The only way the Pennsylvania legislature can take my property is by what? Eminent domain. Then they got to justly compensate me. These are facts, okay? If the Congress can't do it, and they wrote the tax statutes, how's the municipality? Through ordinances, which are not laws. They're corporate bylaws. That's what an ordinance is. So if the legislature can't do it, that wrote these tax statutes, how can the creature of the state, the municipality, how can they seize property that the state can't seize? How can they lien property that the state can't lien? And how can they sell property that the state can't sell? So we jumped over A, and they want to go to B. No. And in my last motion response to Judge Dozer in the Borough Brooklyn Park case, I flat out stated there are no state tax assessments in this matter. In other words, the legislature didn't assess nothing. There's no Commonwealth of Pennsylvania tax assessment. The assessments came from the borough. And by the way, the county can't seize my property. They can't lien my property. They can't sell my property. So then if they can't do it, how is the creature of the state, the borough, how are they able to do what the county can't, what the state can't do? And I got a great court citation in there from Pennsylvania that literally states that. It makes no sense that how can a creature of the state, the county or the borough, do something that the legislature itself cannot do? And that's what Brandon's talking about, where they wanted to jump to point B and talk about the tax thing. No. Let's go back to point A. How did you people get expressly granted the right from the legislature to do what you're doing? Because they can't do what you're doing to my property. So how did you get if they can't
it would mean they have a legally cognizable interest in the property, right? Okay. And look, folks, yes, we've talked ad nauseum about administrative state and why Woodrow Wilson, the first democratic socialist president of the United States and the student of Hegel, okay, which is the dialectical process. When he instituted the administrative state, it was, and he wrote about it in his books. You can go read it if you want. However, his goal was to have a rule by experts and circumnavigate the Constitution. That's it. And somehow we've allowed that to continue. And look, there's no property tax or income tax until 1913. And you can go right to when Woodrow Wilson started it. But nonetheless, and then you have the New Deal, and then you have the welfare state, and then you have all this other crap that has come forward over the last 90 plus years. And, it is human nature to want instant gratification. I'm sorry, folks. It's not how it works. We're at the tail end of 100-year actually 110-year history now of socialist and communist-minded people having direct control of the government of the United States. And just like any other institution in the history of mankind, what happens in the age of decadence is demoralization, destabilization, and then normalize it. And most Americans today do not have any clue what the First Amendment means, what the Second Amendment means, what the Fourth Amendment, what due process means, right? Or that there's a reserving of our rights in the 10th Amendment, that whatever's not enumerated, it goes back to the people, right? Or maybe 9. Nonetheless, but what that actually meant is that, again, the government must be put back into a servant role. And the only way that's going to do that is by people either, one, writing using the judicial branch, because it's still there. As bad as it is right now, there's still good people. There's good rulings coming out of the Fifth Circuit, 11th Circuit, things of that nature. We got to get pleadings to them, though. And just because you bomb out in the trial court, don't stress out. Don't stress out. Understand where you are in this particular time.
And that's why we bang on, I hear people say stupid stuff like, well, statutes are not written for us. Well, you can't say that, because the criminal statutes are written for you. If you kill somebody, they're going to prosecute you under a criminal statute. Now, you're not going to be able to go in court and go, well, listen, yeah, put a gun to his head and I killed him, but that's a statute. It don't apply to me. That's not going to fly. You got to take things in context. You got to read the statute in context. But when you want to argue things in court,
in that context, Alphonse, a lot of the statutes are written for commercial entities. That
I agree, but in context, you got to know
but
what
not criminal.
But you can't say across the board, well, because it's a statute, it don't apply to me. Well, no, I'm going to guess most of the criminal statutes are going to probably apply to you. Unless it's a mala prohibitive, where it's a crime on paper. You didn't really harm anybody, but it's a crime because somebody said it's a crime. That's different. But,
yeah, we're seeing that in New York right now, right?
Yeah, you can't make blanket statements. You got to understand the statutes you're arguing and what they're moving against you, because you need to be able to dissect them using statutory construction, like Brandon use them generis and what is it, non sequitur de sociis. You got to be able to know those concepts, because you got to know that when they're talking about legal entities and they throw person in there, that could not possibly be you, because you're in a group of 6 other legal entities. Legal entities get their rights and powers from Congress. You don't get your rights and powers from Congress. Legal entities get their rights from Congress. So
they get their privileges. Privileges now.
So you can't put me or you in a list of 6 legal entities, because those legal entities only get powers from Congress. You're in a whole different ballpark than them legal entities. You have inherent, indefeasible rights. Okay. In other words, when the Congress creates a creature of the state, which is a municipality or a cop or a judge, they're all creatures of the state. They delegate what powers those people have. They have statutory powers, okay? And in those statutes that govern them, they have statutory remedies. They're locked in the statutes, those people. Those statutory entities are locked into that. What they'll do is they'll try and move a statute against you and try and claim that you only have these statutory remedies. Look, just like a municipality, you got to use the statutory remedy. No. You have constitutional rights, okay, that a statutory entity does not have. So you don't have to be locked into that statute. But to exercise that, you're not going to do it in the lower municipal courts and the state courts. They're going to lock you into that statute, and you're going to say constitutional right. You're going to, what Constitution? We're following the statute. You got to get out of there. And the only way you're going to get out is you got to learn how to write your own pleading. You got to learn how to litigate your own pleading. And you got to get filed in federal district court. And right now, I'm going to tell people, like I said, I think you're better off, as soon as they start with you, go right to federal court. Don't even go through the state process, because they're going to deem you a loser. And then when you file in federal court, they're going to say, Rooker-Feldman, you lost in state court. You can't. No. Go right to federal court. Because right off the bat, what I'm now in the local tax stuff is they've got these local tax cases. Now get this. What's the only way you can commence a civil case, Brandon? What do you need to file to commence a civil case?
A complaint.
You got to file a complaint, right?
Mm-hmm.
So the attorneys here, they file what's called a municipal claim. Right? It's a municipal claim, make a complaint.
Well, that would be under respondent, and that's an administrative action. That means it's a respondent. And what's the other name in an administrative action? Oh, come on! It's not a civil procedure, because it's under the administrative code, but it's a respondent and something else. Well, it's an executive branch action, which states that they already have interest or ownership in the property, and that's why they're going in rem in the first place. Is because they're saying that they have a legally cognizable claim to the property itself.
Now let's look at the rule.
Although they don't realize that's what they're saying by filing the claim, right? And but it would be like I can't remember what it's called when you file like an EEOC C claim and it's respondent and something else, but it's
Me
not.
respondent,
It's not a plaintiff and defendant. That's a true civil case. It's something else. I can't remember,
Right.
but nonetheless.
Now take what I just said there. Now, but let's go back to this is every state. This is your state, my state, every state. In order for the clerk to commence a civil suit, what does she need to have filed, Brandon? She needs a complaint, right?
That's right.
Can't commence a civil suit without a complaint. Now, we just talked about this. That municipal claim he files, that's not a complaint. So when he gives that to the Office of Judicial Support, the court, and she creates a case, didn't she just violate the rules?
Yep.
She took something that's not a complaint and she created a civil suit out of it when she can only create a civil suit with a complaint. That's not a complaint he filed, the attorney. That's an administrative process. She can't create a case like that, okay? Now, so I jammed them up on that, and I'm telling you this so because this is happening in your state too. It's not Pennsylvania specific. Point two, in Pennsylvania it states, and I'm sure it's the same in Louisiana and everywhere. If it involves a lien on property or anything to do with property, you must have service of process by the sheriff. The sheriff must come out and give you service of process. What they do is they send you a letter in the mail, a certified letter. Is that the sheriff serving me? No.
But they use the loophole of you answering it to gain gain jurisdiction over you.
You waived it. Yeah, you waived service.
Right.
You might be right. Okay. So she's commencing cases without complaints. Rule break. Okay, in every state. It involves property. I mean, someone's got to give you a service of process. There's got to be and when service of process is done, the person serving you, they got to file an affidavit of service with the court saying, yeah, I served Brandon. Yep, went out to his house, gave it to him on, March 3rd, 3 p.m. I served him. So now she's violated two things. And in the letter she sends out, the clerk now, get this, a judgment has been issued against you, entered against you. A judgment has been entered against you. A clerk is a glorified secretary, okay? She works for the county. She works in the court. She's a county employee. She can't make judicial decisions, okay? The attorney, he's a third party. He can't make judicial decisions. So that letter she sends out, and she sends out under another rule of civil procedure saying there's a judgment been entered against you. Well, no. She can only notify you of court orders or court judgments. She don't have a court order or a court judgment to send out to you. There is no court order or court judgment because, and I put it in my case law that cited that, a judicial act must be done by a judge, not a secretary, not an Office of Judicial Support manager, an attorney. It's got to be done by a judge. So in their notices, to try and run what Brandon talked about, the municipal administrative claim, it's administrative law. They're trying to conflate the administrative law over into judicial law. They're trying to bring it to give it some validity because they're trying to drag it over to make it look like it's a valid process. And even for them to do that, look what they violated. The clerk violated making a civil case without a complaint. Then she never gave me service of process. She never issued service, okay? Rule violation 2. Rule violation 3. She's claiming that the municipality made a judgment. Can a municipality make a judgment against my property? No. They're not a court. They can't make judgments against my property. 3 rule violations that they're running now to try and get this municipal claim process underway. This is what you call a color of law action. It looks like law. It's coming. Hey, you get a letter from the court. Look, she's got a civil case she created. And look, you got that letter, certified mail. And look, they said there's a judgment against you. But factually, we know that she never had a complaint to create a civil case. She never sent a process server out to serve me. And 3, there's no judgment in the matter because there was never a hearing. A judge never signed off on anything. That's a color of law action. It sure looks like law. They're making it look like law, but it's not the law. It's a violation of the rules of civil procedure. It's a due process violation. It's a substantive right violation. They're literally doing things to mess with your property and cloud your title under a color of law action. So that's what we're saying. Stick them to the rules. It's no more complicated than that. Stick them to the rules.
Yeah, and we have to. And so, and one of the things that, I even have to repeat to myself, right, is because you get these replies in or motions to dismiss, and it's vague generalities. And the attorneys expect the court to grant them. So as of yet, correct me if I'm wrong, Greg, Gary, have we had one material fact put on the record by any of the defendants?
Not one. And they continue to get rulings.
That's right. And so for instance, just to give everybody another falsity within my daughter's opinion, they claim that I failed to plead the first rule to Article 42, 1985, that there was a conspiracy. It's clearly written in there that LCMC in conspiracy with the federal government. Okay, that's the conspiracy. CMS mandated to LCMC that they had to have 100%. It's in the complaint, right? They mandated a directive to the private corporations that in order for them to get the Medicaid and COVID relief funds, they had to have 100% compliance. Okay, however, that's the conspiracy, right? However, the judge skips over that I named the CMS and the CDC and federal government, skips over that and says I didn't name a conspiracy that's cognizable to the Title 42 1985 claim. However, we did. Again, just notice the discrepancies. And one of the things that I've learned over the years, when you get the original motion to dismiss, pay attention to what isn't said more than what is. And just like the judge's opinion, when I read the opinion, I'm deducing logically what's missing. And I only read it today. Gary, when did you get that? Last Thursday, Gary? I went to Gatlinburg this weekend for a vacation, whatever. I told Gary, I'm not touching it. I wasn't going to let it ruin my vacation, because I already knew that when Gary called that it was going to be the jump over. Do not get distracted. Do not get downhearted about the fact that we are the generation that has to start the precipice of the climb back up. We're all the way down, folks. I'm sorry. Every action within this government right now is a theft of our property.
Yeah, and if anyone thinks that there's going to be some political savior on high to come save us, you would be mistaken. The only person that can save you is you. And any other trust in anyone else is just lunacy. It's absolute lunacy. So if we are watching the exposure of these communists and Marxists and Nazis, because they're all on the same left, because on the far right in America is it's anarchy. And that's why the Constitution and our government was placed initially so far close to the right, which is anarchy in America. Now in Europe, the right is the Nazis and the left is the communists and the Marxists. So they have to stay somewhere in the middle. But in America, anarchy is on the right. And so the Marxists, communists, Nazis are all together, and they're all trying to subvert the rule of law. And don't think any one person is going to do it. We all have to do our part.
Now
we do. We really do. And it's unfortunate, but I'll read this from James Madison Property and William T. Hutchinson, and we'll just apply this to our life today and what we're watching transpire in real time. That is not a just government, nor is property secure under it, where the property which a man has in his personal safety and personal liberty is violated by arbitrary seizures of one class of citizens for the service of the rest. Now, I'm going to juxtapose this into reality. And we just have to accept reality. The evidence and the objective facts are there. We have the mass immigration that taxpayers are paying for. We have the Ukraine circle jerk that taxpayers are funding for. We have the homeless and drug epidemics going on that the taxpayers are paying for. We have the medical industrial complex that the taxpayers are paying for. We're actually paying them to kill us with poison. We have the military industrial complex where the money funnels through from taxpayers to Northrop Grumman and all the other facilities, right, to pay $1 million per little bomb or whatever. It is fundamentally opposed to the Constitution and the idea of a constitutional republic, and it is theft all the way across the board, from the middle class man just wanting to be left alone on his property, right, to the man working and getting 40% of his paycheck taken to Social Security. I don't know if y'all saw the Senator Tommy Tuberville yesterday. Somebody sent it to me. Tommy Tuberville sat in the Senate yesterday and on the open floor said that Social Security is bankrupt. Did y'all hear that?
No, they
and then had an expert. Yeah, no, and then had an expert. He turned over to an expert. So as fast as they're taking Social Security, they're spending it now. So on the Senate floor in a hearing yesterday, I guess that's the ex-football coach from Auburn. But anyway, nonetheless, it is criminal what they have done, and it's up to us to hold the criminals accountable in some way, shape, or form or fashion. And with that, guys, it's been a long weekend for me. I'm going to close out. Gary, I don't know if we're going to do this bi-weekly or weekly, but are we going to do a set night?
I'm going to try to. We're going to try to talk to everybody and decide on that. I would like to do it at least once a week, whether you and Alphonse rotate because of y'all's time constraints and things like that. I would like to have you on almost always, one of y'all. But I'm going to start scheduling some interviews with some people that are litigating. I think Jill is willing to come on. That's an amazing entanglement over there and what she's doing on the West Coast. Like, it's just...
And look, and I will say this also. I will say this. I will apply to the Steve and Alphonse idea. Do one complaint at a time if you can. Don't overextend yourself. Especially in the wider range of topics that Gary and I have explored into. It's not conducive to you keeping your sanity, okay? Because the amount of exceptions and immunities written into each step of every different law has to be studied. And it is true that you're going to reach a burnout stage. I think a few of us in Alphonse's group has. Me and Alphonse has talked personally where he was reaching the burnout phase too. It's very tiresome. Remember to take your time. Go step away from it for 2 or 3 days. One of the rules that I do when we get a reply brief in, I don't even look at it for 24 hours. That's the minimum. Don't even look at it. Just go ahead and know that I'm about to read some garbage. Okay? And that's for my own sanity. Do that, and I think everybody will be well off. Jill's a very intelligent lady. But nonetheless...
She spent on that one case. Imagine she had 5 other cases like that. She
couldn't do it.
She'd be running around postal. She'd grab like an Uzi and start shooting people. Okay,
well,
you would go crazy doing that stuff. That long.
Yeah. In all fairness, though, her case is pretty sprawling. I mean, it's really expansive.
What she's doing, you're seeing the curtain be pulled back on the criminality. Like they have like an ex-governor's getting the AG involved in representing them. Well, how's that? She sued in her individual capacity. Like they're doing all kinds of. They just like I sued a judge in his individual capacity. I got a state Supreme Court attorney representing him. Well, how did that work? I didn't assume it as an official capacity. He's being sued as an individual capacity. So what? He gets a free attorney from the Pennsylvania Supreme Court? How's that work?
Sure.
Can I get one of them too? Can I get a free attorney? No. You know.
Well,
and Zippy from.
And I'm not a.
Zippy from.
One thing for you. This is from Pennsylvania now. This applies to us, okay? The 12B shit that we're going through. First thing they do when you file a case, you're getting 12B1, 12B6 motion. Right out of the bat, you're going to get. Now, here's Trinsley versus Pagliaro. Famous Pennsylvania case went to the Supreme Court. Let me read you this one response and how detailed it is, the federal court, and how applicable. Ready? The defendant's motion to dismiss for failure to state a claim, unsupported by affidavits or depositions, is incomplete because it requests this court to consider facts outside of the record which have not been presented in the form required by Rules 12B6 and 56C. Statements of counsel in their briefs or arguments, while enlightening to the court, are not sufficient for purposes of granting a motion to dismiss or summary judgment. In other words, this is everything we're facing right now. Now we're letting these attorneys answer, no affidavits, no nothing, and that right alone is not grounds for that judge to grant the motion to dismiss. It says right there in Trinsley versus Pagliaro. There's nothing to support what that attorney's writing. But what are they doing? They're granting the motions. Total violation of case law, rules. So
which is why we need some media attention, the public's attention on these things, so these judges can have to face the music when they do things of this nature and just completely go off the rails and do what they want to do.
Yep. Yeah, and it has to happen, and that's why that's why we're starting this too. Look. And I just want to interject this one last idea, and I'm not a Trump fan or anything else, but one thing that these cases and the Trump derangement syndrome has revealed with the Fannie Willis and the Judge Engeron ruling $353 million against him without an injured party is just how bad the judicial system has gotten through the Bar Association.
And they're in everything. They're the Bar Association, just about every judge. I don't want to say all. I would say probably 90% of your judges were attorneys or prosecutors or whatever. They're bar members of some sort, okay? So now you got the attorneys are all bar members. So now you got and all your Congress people and your senators, most of them are what? Attorneys. So they infiltrated all three branches of government, okay? And your presidents, a lot of your presidents were ex-attorneys. So now they infiltrated the executive branch, the legislative branch, and the judicial branch. They have infiltrated all three branches of government. This is why we're in the shit that we're in right now, okay? You got the Bar Association, basically rules for thee, not for me, is what we're coming up against, okay? They're not following the rules. If we were following the rules as written, we would all have won already, okay? If we were following the rules, it's literally like us playing a football game and our receiver's got to have 2 feet in bounds, but the receiver, he's only got to get 1 foot in, okay? So we're playing by 2 sets of rules. If we were playing by the same set of rules, we'd be having no trouble. But Brandon, didn't you have people defaulted on answering your complaint?
Say that again?
Didn't you have people default not answering your complaint in time in some of your cases?
I did.
Yeah, that was Gary.
I even got a default ruling from the clerk. And even the Fifth Circuit at this point has said, oh, you're not entitled to a ruling just because you get a default and no one answered the complaint. That's what they said.
That's what that means. You are entitled to.
Yeah. Right.
Okay.
That's right. So they gave away the power of the court completely. It means nothing to get served with a federal complaint these days. This is the tow truck company, our City of Central case. They did not answer. I got a default from the clerk. I have the piece of paper.
You got the default. That should have been it.
That
was the case was done at that point.
I agree, and it says very specifically, if you put an amount in your complaint, that's what they're on the hook for. Period. But the Fifth Circuit, with a Jimmy Carter appointed judge, an Obama appointed judge, and a George W. Bush appointed judge, said doesn't matter.
Yeah.
See, that's where you go to the Supreme Court with that. That's a clear cut.
Well, we just got the final order in today. They agreed that the Fifth Circuit told me we are all going to bear our own expenses, so they didn't try to force attorney fees on me. So I feel like they know they probably did some things unfair here. So it may be. Now, they did rule that it was time barred, although statute of limitations was never brought up properly and was never legally brought up. So that's really not an issue. In fact, they failed to mention it in their answer, but yet it's time barred. And so
you couldn't even get a default judgment.
Couldn't
on
even-
rules.
on a
You
rules.
couldn't even get a default judgment.
Nope.
Yep.
Couldn't. It's absolutely
All
amazing.
right, guys.
All right.
Till the next time, Gary, I'll talk to you tomorrow. Each and everyone out there, we've got. So what I'll do on the Big Sib channel is strictly informational and knowledge-based series like we've been doing. I'm going to do postmodernism next. We're going to explore that particular topic. But what we'll do is we'll move the law over here, and that way it clears up any confusion. If you want the law, it'll be here. But we're not getting any traction on the Big Sib channel under my name. So we're going to try something different. We're going to try another route and see if we can get some traction. All right, Alphonse, catch you on the flip side. Gary, you too, brother.
Peace, brother. Alphonse, if you want to stay, we can. If you need to go, that's cool too. We'll regroup and I will be a little more prepared this time.
No, I'm saying that's the only disheartening thing to me that I'm saying is, listen, you followed the rules, you followed for your default, and that's why the clerk signed it, Gary, because they're the rules. That's what she became an administrator at that point. Okay, she didn't need a judge to tell her. She knows that she's got the court docket in front of her, that they were responsible for supplying an answer on day so and so. She can look at the docket. She sees no answers filed. So now she becomes she goes into a ministerial role. Okay. She don't need a judge now to sign an order.
Oh no! So listen.
The rules.
Listen to this. The clerk wouldn't issue it. And this is the same clerk that has held our filings for 11 days and is completely complicit in a RICO act. And we're going to get to that. But they bumped it up to the judge. The judge had to sign this default. And finally did so after the magistrate first denied it based on. Are you ready for this? Now this is a corporation.
You had the judge sign it.
Yeah. And listen. Yes. And so what was crazy about it was that what was I going to say? The judge signed it, but at first the magistrate rejected it and said, "Oh, we can't grant you this because now we're talking about a corporation, a default judgment against a corporation." Said that you didn't send an affidavit saying that they were not currently serving in the military and that they are above the age of 18. So I had to resubmit it all with an affidavit saying that this corporation, that's 22 years old actually, is definitely above the age of a minor and is not currently serving in the military.
That's incompetent. You know what? You should file against that magistrate. That's incompetence. Okay?
Yeah.
That's not an individual. Corporations don't serve in the military.
Correct. Right. And they don't need to be of age.
No.
Yeah.
But that's the only disheartening thing I see is, like I said, you should have got your default. That should be a done deal.
At minimum. And if they could take property without a warrant, which is what happened here,
Sure.
Then we're all in danger.
You could get that to the Supreme Court that they would affirm that default judgment. That'd be a clear-cut thing. They would look at it and go, They didn't answer.
Right.
What are you guys talking about? Military. How the hell's a corporation serving the military? What are you talking about?
Right. Right.
You might get in the default. That's what it's going to take to go up to there to get that affirmed.
Like I said, so we have a few days to decide what we're going to do on that issue. Is it worth pursuing? Maybe, maybe not. I'm familiar enough with the case. I could probably write a certiorari pretty easily, pretty quickly. So maybe we should do that. And it's only $300 filing fee as opposed to $405 here in the U.S. District Courts. But one other thing I want to ask you about before you leave. In the Tennessee case, we got two answers. We didn't get any 12B motions. We got two answers.
They actually answered the case.
What's that?
So what, you sued two parties then, right?
Yeah, well, I sued three. One party hasn't answered yet, which is overdue.
Are they in default? Is the third party in default?
Yeah, but we're gonna try. But it's just a very different. It's a very different feel from what we've seen down here in Louisiana and Mississippi. In the
southern. You got an answer. You're headed to the trial phase.
Yeah. So I sent him an email yesterday. I sent the lawyers an email yesterday. I said, 26F conference, give me your open schedule. Let's make this happen. Discovery time. And so I imagine.
Use discovery.
Yeah, they're going to try to backdoor a 12B, I'm sure, but they're going to try to backdoor a 12B at some point, I'm sure. But
give you an answer. They can't go back.
Well,
they gave you an answer.
The city of Central did. The city of Central did the same thing. Right.
It's a rule violation. They can't do that.
Yeah.
You can't answer and then try and. You have to do that from the start. They have to file those motions to dismiss.
Wow.
Once they give you an answer, you're in the 26F conference range there, okay?
And
now you got to do the conference.
Okay. Now, neither attorney answered me. It's been 2 days, and they haven't said a peep about the 26F conference.
I'm stunned they didn't 12B1 or 12B6 yet.
Me too. I'm shocked. This is in the Sixth Circuit up in Tennessee.
Still got the memo.
Now
got the pro se memo.
Now there's one other little fact here. When I first mailed the complaint in, the first posted document on Pacer was my complaint, and that the clerk had a handwritten case number with the judges, the initials of the judges, right? Like they do. And the first judge I was assigned was a Donald Trump appointee. White guy, and I looked him up and I was like, oh man, this might be actually something. They rejected so I sent $402 in, and they said, oh, we raised our price to $405, so they had to mail back the check for $3, and I had to remail it back. Well, when I remailed it back, I get the chief judge, a Black Obama appointee. Yeah.
So that shouldn't have changed nothing. They should have called you up and said, oh, by the way, you're $3 short. No problem. I'll send it right in.
Well, the court said I had 20 days to remedy it, which I did remedy under 20 days. So the judges shouldn't have changed. And they initially signed it as a
miscellaneous
marked case. And then they switched it to a civil case, which I'm not sure.
If you didn't give the right amount of money, what are they doing assigning judges?
But fair enough. Fair enough.
Wait a minute, right? If you come to buy something from me or a service,
mm-hmm.
and you don't have the money, I'm not going to do anything. So why would they turn around and start the case by assigning a judge and going, oh, by the way, listen, that's fine if they say, listen, you owe us $3 more. No problem, I'll send you the $3. But that shouldn't undo what they did. Why did they move? That's another thing I want to know. Why did you guys take the case and assign a judge?
Well, I called the clerk, and I was like, I did not screenshot the initial thing when I saw the judge assigned. I didn't think that there was going to be an issue here. And so when I called back, I was like, it was initially this other judge. Oh, no, it never was. Look what's written. And now on the front of the complaint, it's written the judge I have and whatever else. But either way, this is something new, which means it's refreshing to me rather than complete stonewall and complete whatever. It's a little bit different. We got answers on the record, and so we'll see what happens. I don't know, but it's
that's how it really should be. You're supposed to, like I read that Trinsley versus Pagliaro. Listen, if they don't have anything solid to get a motion to dismiss, you're entitled to an answer.
Right, and this is about a case that they've already dropped any charges, and they've expunged the record, so they've admitted their mistake. I offered them a very low settlement, and what did they do? Nothing.
Now they'll spend 10 times that in order just to fight it. They'll spend 10 times that.
Right.
Which they usually do, Right.
And I even
Brandon's daughter's case.
That's right. Yeah, exactly.
Even though he didn't get the decision yet,
and it was
they still spent more money than what he wanted.
No, Brandon got the decision. They just granted the motion to dismiss for his daughter, even though the EEOC put a charge on him. How you can't 12B6 that out. But they did. They did.
And this is the problem we're having, is they're not following the rules.
That's right. That's right.
I don't mind fighting as long as we're both following the same set of rules.
Right.
I can't beat you if my receiver's got to have 2 feet in the field and your guys only got to put 1 foot in. I'm having trouble beating you, okay?
That's right. That's right.
We got to both be on the same playing field.
Yeah. So publicity is necessary, and that's why that I am involved at this point on this level. And I hope that we can garner enough profile that we can, highlight not just mine or Brandon's or yours, but everybody that's in the Telegram group that's been fighting against the tyranny. I mean, Saraf, oh my God, what is this guy going through? And, if we can't...
Listen, Steve...
Go ahead.
Steve, the cornerstone of what he does is the media blitz.
Yeah.
Okay? He said before they file a case, 6 months out, they already got the media blitz set up. They're going to contact these news people, these news outlets, and they work the phones. He's got people there that work the phones, that call up. They got burner phones, okay?
Gotcha.
5 burner phones.
Gotcha.
They call up. Then they call up. This is Fred. Hey, this is Bob, with different voices, Yeah. And what's going on with this case? How did you throw this guy out of his house? They put so much pressure that the media will start like in the case, that famous case he did, John's case, where he got the $38.2 million settlement. They had a Judge Janine Shapiro's show.
Yeah.
Judge Janine Shapiro.
Sure.
Her show was calling up. Nancy Grace's show, they were calling up the county. So they had national media.
Yeah.
Calling the county. Asking,
well, that'll do it. That'll do it every time.
Right.
Every time. And
the FBI guy. They had an FBI agent calling.
Okay.
Asking how you ruined this guy's life over $8,000. When those calls came in, the media calls, they came to the settlement table.
Yeah.
Because they knew this was going to blow up.
Yeah.
So the media is the big thing Steve pushes with me too. And I just don't have the army. That do this right
I look, that's what I'm going to use my spare time to do. Try to build that for us. And I think you missed the first part of my this live stream. I don't know if you're plugged in or not, but that's what I talked about, what we're doing here. And I have begged and pleaded with everyone from state reps to senators to congressmen to the Judiciary Committee to watchdog groups to podcasters to news. I've tried to send out a big press release. The company won't send it for me. Right. And
you need a couple news reporters.
Yeah. And I know some of these representatives and congressmen. I know them personally. And no, who wants to touch suing a federal judge? No, we're pushing issues that are hot button issues, So I get the being in politics my first 10, 15 years of my life, I get the hesitancy. But we have to have enough political pressure to make these people do what we want. We have to do that. So that's where we got to get some media connections. That's what that's the really the thing you need. You need the local guy, the problem solver, or the guy the government that writes articles. You got to get them on your side. Get your complaint to them and get them calling whoever you're suing, like your guys. Like, how did you take this guy's motorcycle without a warrant? Yeah.
How did you do that? And how did you sell it when you don't own it?
That's
you
right.
had a news reporter calling them up and putting heat on them. That scares them, okay?
Yeah.
Because that guy could write an article of what's going on. Hey, this guy had his motorcycle stolen, and he sold it without a warrant, without ownership.
That's right. And one more thing about that case, about being time barred. I proved that it was not time barred based on, I filed an initial complaint. Now it was junk and garbage, but it sat there for 6 months before they kicked it out. That 6 months I'm sitting there should not count against my tolling. And then you get another 30 days after that, after you stop file, after they dismiss the case, according to Ruth Bader Ginsburg, you get 30 more days of tolling. So I proved that I filed on day 341 before, and they said no, they didn't. They didn't want to hear any of that. Didn't want to hear any of that. Said it was time barred.
And that's from the appellate court?
The appellate court said it, yeah. Well, I mean, both courts said it. but crazy.
But you got to try and get that up to the Supreme Court if you can.
Maybe so. Maybe so. I really don't want to let those guys off. I don't want to do it. They are nasty people. So.
No, like I said, you have a really, that's the sad part, is you have a very real clear-cut case. It's easy to understand.
Yeah.
Took it without a warrant. Case should be over at that point. When you take it without a warrant, we're done at that point, okay? Then to make add insult to injury, then they sell something that they don't own.
Yeah,
so now they stole property and sold it. So
right.
Faux pas number 2. And now they want to play legal games with filing times and blah, blah, blah. And
and the of course the appellate court even said, well, the state of Louisiana has every right to seize property that doesn't blah blah blah. I was like, where the Fourth Amendment? Where's the Fourth Amendment? Like, what? Where's the warrant? No, it doesn't have the right to do that at all without a warrant.
Yeah. See, Steve had a case like that in Florida, and they took the guy's. I think you seen a video probably up on the internet, but they set cameras up because they knew they were going to take the car. It was an $800 K car, so they put cameras. And 3 cops showed up with the code guy, the code idiot, and they towed the car. And while they towed the car, they damaged his yard. They damaged some brickwork, So Steve didn't sue the county or the municipality. He only sued the towing company. Sued them alone. Grand theft auto. Guy stole a car without a warrant.
That's exactly right.
When he sued them, they case just started. They had a break. They took a break. The lawyer actually came up to Steve in the hallway and said, "We cannot defend this." He admitted we cannot, and I think that settled for like $165,000. They settled that.
Yeah.
That's how it should have happened. Okay.
Sure.
He got him. You guys took the car without a warrant. Okay. That's grand theft auto. You can't do that.
Yeah.
That's your case right there.
The amount of money that these people spend on lawyers and fighting it. I mean, I guess I get why, because you can't have everybody doing it. Otherwise, their scheme comes apart. But if they would just come to the.
How much was your bike worth, ballpark?
I mean, I only paid $2,700, but I was probably worth a little more than that. But
How much money you think they spent defending this case?
Well,
$100,000.
I mean, I filed in 2021, and it just ended. So, a lot, a lot.
A lot more than $3,000, right?
A lot more than $3,000 for sure.
So they could have given you $3,000 and made you go away and wrote it off on their insurance.
Yeah.
Instead, they probably spent $300,000.
Yep, and at least the appellate court made them pay their own bill, so that's great. So
makes no sense.
It makes absolutely no sense.
It makes no sense whatsoever.
No, it doesn't.
Instead of giving you your money and making you whole for $3,000 that you probably would have went away.
Yeah, if you give me my property back, I'd have went away. Give me my property back, I'd have went away. But anyway, it is what it is, and we will continue to expose them and continue to make a list of these people to have impeached or whatever needs to be done, or voted out of office, or
So that's where, and that's just to give an update. That's where I'm at with my 2 cases. The first case, the county case, the one he tried to call a tax case, we filed a motion for reconsideration. That's been sitting there for 3 months now. Okay, he's not ruled on that.
Yeah.
Second case, he's been sitting on for a month now. I sued 2 attorneys, a judge. So they did their standard 12B1, 12B6 crap and filed the responses. I told Steve, I think he's holding the first case to decide on what he's going to do with the second case because they're pretty intertwined. They're very close together. And he's got to watch what he rules because the second case is real bad. Because I got affidavits from the borough manager. Gary, here's how bad it is. I got the attorney that filed the liens, okay? I sent a record request in to the borough and said, who authorized the third-party debt collector to file liens? Know what he said? We have no records in our possession of that. So let me get this straight. You hired this law firm. You don't have any records. So what, the attorney woke up one day and decided, let me go file some liens against Mr. Fat Joe. So now I got that in affidavit form, though. And I'm saying, listen, I got the borough manager saying he don't know who told the attorney to file it. So, listen, I'm a common sense man. I think the attorney filed it on his own for financial gain. Oh, by the way, I got an affidavit from the borough manager proving it. He don't know who filed it. So now the judge has a problem. He's got an affidavit in a way that doesn't support anything the law firm did. Can't explain anything the law firm did. So now they got to try and get around the affidavit. I didn't say it. The borough manager did an affidavit. He don't know who told the guy to do it. Isn't that law firm an agent? They can only do what the client tells them to do, right?
That's in theory.
So let me get this straight. They filed liens, but the client didn't tell them to file liens because they don't have no records of who told them to file the lien. So now they have a rogue law firm running around. Now here's the problem. The law firm that's doing this, she handles 200 municipalities in Pennsylvania in 25 of the 67 counties. We're talking federal racketeering on a massive level. This isn't some little law firm. 200 municipalities. Now get this. They forged the writs. There's a writ of Sir Fossey, okay? And on the language of the writ, it says president of the court signature and date. Guess what's not on the writ?
The president's signature.
Gone. Not only is it not there, they just removed the entire section. They took it out.
Yeah,
now,
they don't need that, Alphonse.
To explain to people, a writ is a judicial order, okay? That means it must be signed by a judge, not a clerk, okay? The only way a clerk can sign a writ is in what's called a judgment by confession case. That would be when you get a mortgage or a loan, when you sign that loan document, in that document, there's a judgment by confession clause. They call it a cognitive clause and a warrant of attorney clause. But really what you're doing is when you sign that loan agreement for a mortgage or for anything, you're granting the lender a warrant of attorney to bypass standard legal process. In other words, don't have to go through an entire trial. When you sign that document, he can go right to the clerk and get a default judgment on you. Because why? You agreed to it already in contract. That's what a judgment by confession is. Okay? But she's now taking that and conflating it with other things. In other words, she can only sign that writ if that was a mortgage case or a loan or something, and I was in default. She could then sign that. We don't need the president of court signature on there. But we don't have that. There is no judgment by confession here. So she can't sign that without the judge signing it. Well, this isn't one case they did this in. She handles 200 municipalities.
Oh, I imagine.
How many thousands of writs has this law firm done to take people's homes? How many tens of millions of dollars have they taken from people with phony writs? Because this is going to blow up, because we're going to find out how a clerk without any judge's signature is issuing writs. And it's not just going on in this one county. It's going on the other 66 counties in Pennsylvania. How many hundreds of millions of dollars, how many homes have you people stolen forging these writs? These are counterfeit documents you're creating here. That's before him now in the second case, which complicates it. Because how's a federal judge, look at it and go, yeah, the clerk can sign it without a judge. Yeah, he created judicial writ, no problem.
Hey, I'm not going to be shocked if he does, but that's the issue here. We're pushing such major narratives with our case. These aren't just simple, oh well, they'll owe you $100,000 or something like that. I mean, we are suing a federal judge. You're suing God knows who, and the property tax issues and all of these things. These are major things that have to come to the forefront. So they're going to do everything they can to delay it as long as they can. And if they can sweep you under the rug, they absolutely are going to do so.
And what's going on is usually, like they tell you, what's the first thing you're told to do? Go hire an attorney, right? When you get in trouble, get an attorney.
Of course.
Because an attorney's not going to do this stuff.
No.
So guys like Brandon, you, me, Steve, whatever, we got the rule book. We got American jurisprudence, and you got the Westlaw subscription, and we got that. We read case law, and we have the rules. We know the rules. They've never had people like us come at them using the actual law, the actual rules, and that are bringing up things going, wait a minute, wait, you sent this municipal claim to the court, but it's not a complaint. And when the clerk got it, she started a civil case. She can't start a civil case without a complaint. How'd you do that? This is Columbo stuff, okay? An attorney would never do that to them. You and me would do that to them because we look at the rules and go, wait, she needs a complaint.
I've got no allegiance.
By the way, look, the law says if it involves property and it's a lien, the sheriff's got to serve it. Oh, there's no sheriff showed up to serve anything. This is stuff an attorney won't do. And oh, by the way, you told me there's a judgment entered, but there's no judge's signature on anything. There's never been a hearing. There's never been a trial. How did you get a judgment? Oh, the borough made a judgment. The borough made a judgment. Borough's a stack of papers. They can't make any judgments against my property. This is stuff an attorney won't do. This is what they're worried about. Now we're putting them under the microscope and going, what you're doing is called an impossibility of law. It can't be done. And if you're doing it, it's a color of law action because clerks don't sign writs. Clerks don't sign orders, okay? Can't be done. And unless we're going to turn the entire legal system on its head and suddenly decide that clerks can issue orders, then we don't need courts.
That's right.
We need clerks, And this is the problem they're going to have with guys like me, you, and Brandon is this is why my second case, I think, threw a monkey wrench into things because it's the elephant with his nose under the tent, and I got a magnifying glass on the stuff that's I can explain it in a heartbeat to a court, right? Listen, a writ, imagine a jury. A writ's got to be signed by a judge. Look, here's the law. Look what it says. See where it says judge's signature? There it is. That's what the legislature wrote. Look what they wrote up. Look what they took off. They took the judge's signature off. So if the clerk can't write an order, is this a court order?
No.
Well,
no.
The judge didn't sign it. I can explain that to the guy under the bridge who lives under the bridge. He can understand that. This is not a complicated topic, okay?
No.
When I show you the rules, it says, look, a complaint's got to be filed. See this thing? He's got this claim. That's not a complaint. Sir, is this a complaint? Well, no, it's a municipal claim. So it's not a complaint, right? No. See, jury? This ain't a complaint. Look what the rules say. The clerk can only start a civil suit with a complaint. Right. This is basic stuff.
Look, you're right. It's basic stuff. When we put our injunction in against the U.S. Marshals and whatever, when I go to the courthouse, I am assigned an armed guard to follow me around the courthouse. Now,
special, man.
Now, our shoes have to come off. They have to take our belt off. They have to do special searches for us and assign me an armed guard.
You guys should take everything. You know what you should do when you walk in? Take everything off down to your underwear and go, all right, I'm good. And walk around in your underwear.
They're looking for a reason to arrest us, I'm sure. But but the judge's like, oh, you don't need an injunction. Well, what is that completely normal? Is that normal for a completely peaceful person going in to file papers with the clerk needs an armed guard? Well, wouldn't issue the injunction. So he denies the injunction. He doesn't issue findings of facts and conclusions of law, which are required by Rule 52, required of the judge. That he's like, it's premature to issue all that. So we do a 52 motion explaining to him exactly what the administrative law is, why he can't do that, why this doesn't want to hear it. Nope, it's premature. So we filed summary judgment, and it's sitting there, and so are the 12B6 motions. It's been, when I filed the summary judgment, it had been 230 days the 12B6 motions were sitting there. And he won't issue an injunction. He won't. The only thing the court gave us in this whole case is they gave us e-filing privileges in the Middle District because the clerk was holding our filings up to 11 days and changing rules in the background to alter the case. So he had to give us e-filing. And they're mad about that. They're mad about it. But that's the only concession we've gotten. He won't even tell us if we're going by the Western District rule, because they had to remove it out of the Middle District. He won't even go on record, even when we asked him in writing, are we under the rules of the Western District or the Middle District? Because you've used both rules to your advantage. Which one is it? Won't answer. Will not. Just gives you a circle jerk when you ask.
Well, that's right there. You got a due process violation right there. I don't even know what rules to argue. I don't know whether I'm in this district or this district over here.
That's right. That's right. It's amazing. It is amazing. And you can't get anyone in the press, any state representative, any congressman to even care about this. Like, what is going on?
Yeah, that's the problem that we're having. I said you got to get a handful of media people that are going to start making calls and ask questions like that. Like, wait, how'd you do this to this guy? How'd you take his bike without a warrant? How did you do that?
Right.
We don't have that. We don't have the pressure on them.
We don't.
And that's the problem we're having.
Yeah.
The only one know the case is going on are me and you and the attorney and the judge. If we had media people calling up and making calls to the county going, how'd you take this guy's motorcycle? How'd you sell this guy's motorcycle?
Right. No, that's why we're here doing this. But on top of that, we're doing it to make more informative videos on specific topics that we can help beginners and advanced people know and understand the experience that others have gone through, so we can negate that in the future and avoid all the hurdles and things of that nature. So I hope that we can turn it.
So that's what I'm waiting. That's what I'm waiting on my second case. I'm waiting for the response back for their motion to dismiss, and I threw a bunch of roadblocks up. So that I'm in that 12B1, 12B6. God knows how long he's going to get to it. Maybe he's going to go to Bahama vacation and come back and make a decision. I don't know. No time frame on it.
Sure.
But he's looking for a way. Listen, like I said, senior judge. He just happened to get both my cases. He's still looking for a way out of this. But the problem he's going to have with this is I flat out state this is not a tax case. Okay. And by the way, you want to argue about Rooker-Feldman? Let's go talk about jurisdiction. By the way, there was never a complaint filed. Remember, we talked about that. Okay. Never had service. That denies you subject matter jurisdiction. That denies you personal jurisdiction. And by the way, you can't bring an in rem action against the property. Why? You need property. You need ownership or interest in the property to bring an in rem action. The county, the borough don't have that. So you don't subject matter, in personam or in rem jurisdiction. The court never had jurisdiction. That means the judge has no immunity. Right. So I stuck that in their face. Okay. I don't know how he's going to try. He's going to walk around this.
Yeah.
All right. I don't know how he's going to walk around this. I'm trying to make it as difficult as possible.
And that's a federal judge, right?
Federal judge, same federal judge. He's got both cases now.
Yeah.
He's got to watch himself because what he ruled on the second case is tied into the first case. And he's got a problem here because now he got affidavit. Remember Trinity versus Pagliara? I'm the guy with the affidavit from the borough manager.
Right.
And I asked him about, get this, Gary, here's what they do too. Here, look how slimy this is. Listen, your municipalities, they have a solicitor on staff, okay? That's their legal person. But what they always do now, they bring in other law firms, third-party law firms they bring in to do tax collection, to do other stuff. The solicitor handles certain things, and they bring other law firms in. So for this tax bullshit, here's what they did. The law firm sends out a letter, says, we're a debt collector, okay? Trying to collect the debt for the borough.
So you have no rights whatsoever.
I got the case that law firm's in, Portnoy Law Associates. I got a Pennsylvania case. They go into, know what they said? The Supreme Court, Pennsylvania Supreme Court. A debt has to be by contract. A tax is not a debt. So if you're saying you're a debt collector, there's got to be a contract in place.
Right, because you have no authority otherwise. None.
You have no authority to do anything otherwise.
Right.
And they say a tax does not set up a creditor-debtor relationship, okay? If they're saying you owe a tax, they don't become a creditor and you don't become a debtor. That only happens in a contract case where if you paid for services and you didn't pay them for services, they will become a creditor with a judgment against you and you will be the debtor. Why? Because you had a contract that you violated.
Right.
So you have a third-party law firm masquerading as a debt collector. Hey, we're a debt collector. They're actually trying to collect a tax. So I'm going to lead them. Same firm I'm suing. I'm going to lead them down the road again. I'm going to respond to one of their letters now. I'm going to say, per rule title 15, right in 15 it says, I need the debt verified. And oh, by the way, a debt can only come by a contract. Look, here's the case that you people were involved in that was cited to you. A debt is by contract. You told me you're a debt collector. I need you to produce the contracts here.
Wedding signatures.
With no signatures, don't ever contact me again.
Right.
That's going to be the response. And what they'll do, they'll file another municipal claim. Now, let's get this. I got the case going on against them. They filed new municipal claims against me. Know what I did? I wrote a 10-page response. No, I think it was 7 pages. Back to the clerk. I cited all the rule violations. I said, oh, by the way, here's all your 3 mailings back. These aren't civil cases. You don't have a complaint in here. You have no complaint. You can't do a judgment. You're not a judge. You can't have a judgment. Oh, by the way, you never served me anything. These aren't cases. Here, take them back. Get rid of them. I haven't heard back from them yet. I'm sure they're still open, but I'm not going to play the game. I'm not going to show up and defend it. Why? Because there are no cases filed. Until you have a complaint filed and me served, I'm not going into that court. And if you want to keep pressing it and you try and set a hearing, now I'm going to sue you again. Now I'm bringing another federal case against you because you're not following the goddamn rules. And now I got to get this judge to tell me that they don't need to follow the rules. They don't need to follow the rules of civil procedure.
No.
I'm going to force his hand. I'm going to make them tell me that these people are special. They don't need to follow the rules. Because I'm sorry, the appellate court's not going to go for that. And there's no way that that's going to fly. This is basic stuff here. So we'll see where we go with this.
Look, a federal case, what the things you bought and what we brought should be over in about 4 months.
Yeah, easy.
Should be over. Because no one's willing to put anything on the record except us. And so if that doesn't qualify for a 12B6 dismissal, then...
What did you say? No affidavits, no depositions, no nothing.
Nothing. Not one fact on the record in any of our 6 cases to date. Not one.
Then it says it's not sufficient for the grant of motion for summary judgment or
absolutely. Absolutely.
And what are they doing? They're granting them anyway, aren't they?
Well, they only grant so far. It's just Brandon's daughter's case that they've granted that in. In mine, it was time barred. and they're trying to remand the wildlife fisheries. But so no motions to dismiss have been granted other than so that's the first one we've seen granted. But they just sit on it. They just, as long as they want to. Well, we can't do that because we have these motions to dismiss pending. Well, get on with it.
Yeah.
Get on with it.
Yeah. That's why. Listen, I know he's going to try and get rid of this second case too, and that'll bring 2 appeals will be go to the appellate court, and in those appeals, we're going to bang the 12B stuff. Okay. We want a ruling from the appellate court. Listen, we're looking at the rules here. Nowhere does it say when they file 12B1, 12B6 motion that everything comes to a halt, everything goes on vacation, and we just sit around and wait 12 months till a judge decides he's going to get to it. I can't find that anywhere in the rules, because if that's how it works, it should say, what's the response? 8T or something? You have to get the answer. Is 8T the rule? I think.
I think we have 14 or 21 days here.
So we're going to ask, hey, wait a minute. If that was the way it works, where they file 12B1, 12B6 motion, it should say when the 12B1, 12B6 motion are filed, this now suspends rule so-and-so for the response. This now suspends that until you get a ruling. It says that nowhere in the 12B motion. It says you can file it. Doesn't say it stops everything, but that's how they're treating it. So we're going to get a response from the appellate court. We want case law. We want specifics on where you came to this point where when they filed a 12B1, 12B6, everything. In other words, the attorney doesn't have to set it for a hearing. 12B motion, they never do. When they file that 12B1, 12B6 motion, they should set that for a hearing to get rid of the case. They don't. They just file it to delay the case. And knowing the judge's going to sit on it for 6 months, 9 months, a year, and this is not how the court system's supposed to work.
No, and if you pick up the rules of Federal Rules of Civil Procedure, you read it, you think, wow, this is really detailed. And then you start getting into litigation, like, I cannot believe they can interpret it that way. Like, what? So it leaves open. It really does leave open a lot of holes that need to be sealed up. But I don't have any hope of getting that done. But
all right, well, that's where I'm at. So I'm just sort of in a limbo land right now, waiting for. Yeah. He's got a motion to reconsider that he's got to answer, and he's got to answer their motion to dismisses. And I think the last response I filed, I can't write it any better than that. Up on my Telegram group, go download my motion plaintiff response to Barry C. Dozer.
I saw you post that. I skimmed through it, and I wouldn't want to be that guy. I would not want to be that guy. I don't know
what other way I could write it that way. Basically, it is basic. You don't have to be. It's not complicated. I mean, you don't need a law degree to read that and understand it. It walks you through it. It says, look, this rule says you need a complaint. They never filed a complaint. This rule says the sheriff's got to serve it. Sheriff never served it. Oh, they said they had in rem jurisdiction, but in rem, look, here's 5 cases say you need ownership or interest in the property. They don't have ownership or interest. They never had in rem. So in other words, they never had jurisdiction.
That's right.
That means the judge, he couldn't have acted in a judicial capacity. Why? Because he had no jurisdiction acting in judicial capacity. So now he got a problem with his immunity.
Yeah, same situation as Shelley D. Dick trying to force us to take vaccines to come to the courthouse. You don't have any jurisdiction over us. Same exact situation. Right. Same exact situation. No jurisdiction. But we're approaching.
That's where I'm at. So you let me know when you want to do the other one. We'll get Brandon whatever together. But just right now we're in limbo, and we would tell you get into Telegram groups. If there's get in the group of Telegram groups, and
I'm gonna work on our technical difficulties here, and we're gonna start planning out. Brandon and I have a list of things we want to do on specific educational things here that we're gonna get to and release them separately, and hopefully start drawing some attention and crowd and actually teaching some basics and things of that nature. And I'll end with this: we're in limbo too, waiting on tribal court. We're going to tribal court. This is a joke. When you call there, they're like, the clerk's out. The clerk's out. Not like, what? What? Anyway, But thank you everybody that showed up. I apologize for all the technical difficulties, and I will work hard to fix all those things moving forward, and we look forward to serving the community in any way we can. Alphonse, always great to see you. Always a pleasure. You're always a fiery guest. I love to hear you talk about Mr. Dozer and the like. But you have a good
Remember,
night.
Gary.
All right, buddy.
Not against you, Gary.
No, right.
Not against you.
Right.
All right, man.
So we'll catch y'all next time. Y'all have a good night.